Good evening, everybody. It is extremely freezing, hence the blanket. But welcome back, man, to the Wednesday webinar with the Property Law Alliance. As always, it's so good to have you with us, especially seeing as that last week we took a bit of a break because of the holiday. So it's really exciting to be back and to have, as always, Cilna with us. Cilna, how are you?
I'm good. I am so sad that you're cold because I'm heading towards spring. Basically, always, every year, the 21st of June is a miserable day in my life. I hate it because I'm like, it's the shortest day and I feel it. Like I can feel it in my soul that it's the shortest day. And then the 22nd of June, yellow, I can feel spring in the air. I am ready for spring. So I'm good. We're heading towards
Very good. Bruno,
So
are you also feeling spring? Do you have shorts on underneath that where we can't see?
Yes, exactly. I got shorts on right now.
Feeling spring. Still, sorry, you were going to say something.
And no, I'm saying you can drop the blanket, eh? It's all in the mind though. Like if we head into
I will try.
spring, exactly.
If my body goes into hypothermia, I will tell the doctor, listen, it's all in my mind.
Well, then you should come and visit me because I do full thermogenesis. So I swim currently outside in a pool. Yeah, every
Nice.
second day. Yeah, I'm that person. So, you know, as much as I moan about cold, I'm that loser in the swimming pool and usually in the evening.
Sounds like some ice princess kind of stuff going on here.
Yeah.
In the wise words of Queen Elsa, the cold never bothered me anyway.
Yeah. See, I do a lot of stuff, but that is not one of them.
Sure. So now you've got guts. You've got guts. You really do.
Oh no, brain. It can really.
You definitely have a brain, and that's why you're one of our experts. Bruno, how are you doing?
No, I'm good. Weather is feeling a bit better, so I'm happy with that. Busy, COVID a bit crazy. Like getting stuck working from home. My trip to Durban this week was cancelled, so that's a whole bunch of meetings lined up that we just had to kind of chuck away. So yeah, that's not very cool, but yeah, what can you do? It's you make the best out of it.
So no, it's really scary times that we're going through, but it's good to have you both with us. And to our viewers out there, I hope that you all are keeping safe as well. So sorry, I keep speaking over you.
No. I wanted to interrupt, and we didn't even discuss this, but I think now, Bruno, when you mentioned COVID, I think it is actually appropriate. We haven't had an episode since Riaan's passing. And I think since he's a close friend of us, I think it is appropriate to also just mention that and really just send our condolences on behalf of all of us to Angelique and their daughter. And really, I think the entire industry is still mourning Riaan Naude's passing. So I think it is appropriate from our side also just to send love and regards to everybody. It's a very sad and scary time actually that we are in right now. So to everybody that's mourning Riaan's passing, we are with you, right there with you. And for everybody that's sick, my partner actually just recovered from COVID, and I just heard one of my associates is sick. And I know there's a lot of people out there that is struggling right now. Seriously, we just want to say you are in our prayers and thoughts, and seriously all the happiness to you guys.
Absolutely. And I think we had this conversation actually, it was that very morning. Was it last week Wednesday or the week before Wednesday? And you know, we implore everyone, guys, keep safe. It's no joke. And like Riaan's passing, so firstly we were close to Riaan, so we did work with Riaan, we socialized with him. You know, there were good friendships there to begin with, but the one thing that also dawned on us is it's getting to the point where, previously you used to look at COVID and try and find a way out of it. Say, well, I don't fall within that group or that class or whatever the case is. My impact is less. It won't happen to me. That whole concept of the universe. You're the center of your own universe. But the reality is that was a wake-up call. The amount of cases that I'm experiencing nowadays with people that I know versus first and second wave is astronomical. So not to say that I never took it seriously, because we always did. But this time round, it's back, it's meaner, and it's right at your doorstep. So let's just try, work together to get through this wave, get into summer. Hopefully then our immune systems are a bit stronger and we can deal with anything else that comes.
Definitely, 100%, Bruno and Cilna. Thank you guys so much. I think on that note, let's get straight into our topic or agenda for this evening. We have a question that was asked by an individual named Mams Silawane, and she asks, she states that the directors of the estate where she resides have imposed a recycling regime which the residents have to finance through their levies, this being an additional fee. She states that the residents of the estate have queried as to how their funds will be utilized and how the decision was reached in the absence of consultation with the residents. She indicates that they were informed that the decision is not optional. She wants to know whether this is legal, and if yes, does this mean that the directors can impose additional fees for whatever they want, whenever they want? I think let's throw this one to Cilna. Cilna, can we help Mams out with this?
I was wondering who's going to get this one. So I'm happy to take him. So the truth is, the fact that she's using the term directors makes me think this is a homeowners association. So my answer would have been the same, whether it be a body corporate or homeowners association. So whether it was trustees or directors, my answer would have been the same. Day-to-day operational, now I stole your word, Bruno, day-to-day operational functioning of a body corporate or a homeowners association is within the power of the directors or trustees to make the decisions as they come up. So if the question was that decided instead of having the refuse removed by Pick It Up or whoever, they've decided to let it be collected by a composting place or whatever the situation might have been, and it wouldn't have affected the levy. Definitely the trustees or the directors would have been allowed to make that decision without consulting the rest of the body corporate or homeowners association. However, the moment it will affect your levy or it will affect your return on investment, so your investment value, then suddenly it becomes a decision that cannot be made exclusively by the directors or the trustees. Now it's a special general meeting. And for that, you need to follow very specific rules, certain timelines on notice, certain amount of people that you need to reach quorum. I can't believe I just said that word in public. My Afrikaans tongue can't get around that word, or squirrel. It's not, I can't do that. It's, but I said it, so I think I pulled it off medium. Okay, you knew what I was talking about. So you need to reach quorum to, and now you're always going to laugh at that, Bruno. So and so for those decisions, you do need everybody's decisions. So they definitely can't just make decisions willy-nilly and pass the fee on to the owners in the property. Definitely not, unless, and this is again a lawyer's thing, we will state the rule and then we say something silly like unless of however, and then you take a whole turn. It's like when a judge delivers a judgment. You think you like in the right direction and you like, yeah, this is going my way, and then he takes a turn and you fall flat on your face. So the however part on this one is, if there was, say, for instance, an AGM or an SGM for that matter, where the body corporate or the Homeowners Association made specific decisions and allowed on a decision potential move to a different refuge removal thing or whatever the case might be. Previously, even before this particular owner bought into the property, and the body corporate is only actioning on this now, it could still be allowed. So I just don't want to say flat out, no, it's definitely disallowed. You're going to have to do some homework and go back to previous AGM's minutes to see what was the resolutions that was finalized during those meetings. But my gut feel on this is it's extremely unlikely that something like that would have happened, and not everybody was aware of it. So it doesn't sound right, but if there is a serious problem and nobody wants to fix it, remember this is why CSOS exists. So the Community Schemes Combat Services, you're not going to get a satisfying answer very quickly, but at least you have a forum to approach for all intents and purposes free of charge. Bruno, help me out.
Nice. So, and I absolutely,
Bruno,
so totally agree.
Bruno, please can you just pronounce quorum before you start? I want to hear you say it in Portuguese way now.
Quorum.
I'm just joking.
See,
Please
I
go
don't know
ahead.
if I'm saying it right. Quorum.
It's like when you think of breathing, like, am I doing it right?
Wow. Yeah, so Cilna's absolutely right. To jump into a bit, maybe slight detail on the differences between a HOA and a sectional scheme, because sectional schemes are actually governed by specific legislation. You'll find that it's a lot harder to get away with things like this because the rules are drafted in a specific way. There's specific regulations regarding the body corporate's entitlement to levy fees or penalties or charges or whatever the case is, unless it's actually included in the rules and it's justifiable and it's reasonable so the sectional title legislation does make it particularly hard. So if this person is referring to a body corporate that's trying to make this decision, to Cilna's point, unless this has been decided before and it's now simply being actioned, it's going to be very difficult for them to get away with this because they're increasing the levy, which is something that the owners in conjunction need to agree to. They're not simply making an operational decision. With the HOA, very, very, very similar, except because the legislation doesn't necessarily cover it, there could be certain loopholes, like the wording of the rules, for example, could be a bit more open-ended to almost allow something to be actioned up to a certain point, which I don't think CSOS would allow with body corporate. So it's a kind of it just takes it one step a little bit further. With the HOA, just double check your rules to make sure that there isn't a strange, or like your MOI, for example, just to make sure that there isn't something strange there that almost gives this authority, because then you might need to go to the core to try to figure out whether they've overstepped their bounds or not, or whether they would be entitled to, because maybe there is something there that speaks about recycling and being green and initiatives and additional costs that can be implemented. It's something like that could exist. Unlikely, but just be careful. Check the rules in the MOI if it is a HOA.
Oh, thanks, Bruno. Thank you, Cilna. I have another question here by Mr. Pillay, and the question is for both of you, but I think we'll start with Bruno on this one. Mr. Pillay is in the process of purchasing a property, which is a vacant stand. He signed an offer to purchase in November last year and put the necessary guarantees in place. It went in for registration, and a week after this, he was contacted by a law firm who informed him that there was a previous sale that was for the same bit of property, which was in June 2020. He indicates that this purported sale had no timelines attached to it for the guarantees to be put in place. And in June, 1/3 of this amount, which was due for the property, was paid up front. And the remaining 2/3, there was no timeline to provide this balance. He states that the sale was never communicated with him at the time he put in the offer to purchase and at the time he put in his guarantees. He has to date incurred quite a considerable amount with regard to this particular matter. Bruno, do we have any recourse here for you?
So this reminds me of a case that a colleague of mine, I can't remember who, very recently dealt with. So Cilna, I don't know if you want to do the honors and maybe just speak about that case quickly, and then we can build up from there.
Well, if we're referring to that case, then we actually should have had Claire, one of our senior associates who was the attorney of record on that one, as a guest for tonight. Maybe we should do that. But so the simple rule, there isn't something that you can just say, okay, this guy signed first in June, the next one was in November, so the one that's there first is the one that is the one that may take transfer. It's a very complex question in law, but it's a very nice question. I think that's why Bruno and I were both very excited about this one. So thank you very much, Mr. Pillay, for the question. To get a bunch of lawyers excited about a question is quite something. So thank you. So the starting point would be two principles in law. So the one is prior res tempore, prior res jure, being first in time, first in right. So the one that signed the agreement first, what is it with me and the Latin tonight? Prima facie, so with, what's a better word? If you just look at it, it seems typically that person would be the one with the stronger right. So if you think first in time, first in right, the quick, easy answer would be, okay, cool. The guy that signed an OTP in June would be the person that would be entitled to take transfer of the property. However, there's another rule, the Nemo plus Juris rule, which says you're not allowed to give away more rights than the rights that you possess. Now, the truth is, the right of ownership isn't one right. It's a complex collection of rights. The moment you as an owner signs an offer to purchase with another party or a sale agreement with another party, you do effectively limit your own right in a way. You're not taking your right of ownership away yet, only transfer in the deeds office, finalize the end of your right of ownership. But you conclude a sale agreement already limits your right to the point where we say, well, you no longer have that right to sell the property because you already committed the sale to another party. And then the first in time, first in right rule kicks in, and you will say, okay, but the first party, let's look at the conditions and let's look at the suspensive conditions. So what I've heard here is 1/3 of the purchase price was paid in June already. That does in a way tell me there is a risk of this contract being perfected, but it's not necessarily the case, because if there wasn't any other timelines for payment of the purchase price, it could very well mean that the seller wasn't actually of the intention of selling this property to that guy, but where was the purchase price paid? So if the purchase price is lying happily in an attorney's trust account, nobody knows about it, seller forgot about it, purchaser sort of, I mean, doesn't really miss $1 million in his bank account. You know, these things happen. So it could show us something about the intention of the parties. But now we have a secondary sale in November. A lot of time has passed since the third purchase price was paid to this point. What's interesting is it's not a crisis for me that there wasn't payment dates for the purchase price. What I do find interesting is that the seller didn't utilize his right to place the purchaser on terms, and if he didn't pay the remainder of the purchase price, to cancel the deal. I don't know why this didn't happen, but you know, that's the joy about this show. We never have the full facts, and we have to sort of wing it through an exam question. But what's very important to note is our case law currently is pointing in a direction where both parties in this transaction, the first purchaser, the second purchaser, both has a right to go to court. And you can do a number of things. You can obtain an interdict, interdicting the first party from taking transfer, or the secondary party taking transfer. Or you can push towards transfer, because our case law is in fact indicating quite clearly that yes, we see you on the prior res tempore, prior res jure, we see you on nemo plus juris, we see the whole thing, but first to order or first to transfer could very well be the successful party. So in a very big way, this is a bit of a race. Okay, Bruno, now I'll shut up. That was a very long intro to that one.
Nice. Yeah, so I absolutely agree with you. If we're looking at, so let's take away properties for a second, because I think the fact that we're dealing with immovable property, the fact that we're dealing with the deeds office, and so everyone kind of understands the deeds office kind of creates an environment of certainty. We've got a great deeds registry system, actually it's one of the most advanced in the world. And the beauty behind it is you tend to know who owns what properties, and that's very important. So we've got title deeds, we've got a proper registry, there's rarely any confusion, right? But with that also comes a level of, like someone mentioned, like prima facie approach to this, which means that even if technically a property shouldn't have been transferred, the reality is if the deeds office reflects an owner, you'd really have to go in and prove otherwise. Otherwise, it's accepted that that is in fact the owner. That's the typical approach that we have with the strong deeds registry system, right? And why you have to jump through hoops to get a property registered, why the conveyancer needs to be an admitted attorney. It's not just a matter of ticking a box and going, oh, cool, I'm owner now, right? So that's the thing with property. So if we move away from this and we just look at a contractual relationship where there's an item that's sold to one person and then sold to another person, right? If the intention is to retain the legal enforcement of that first agreement, and I suppose it comes down to the agreement itself. So this agreement didn't have timeframes. You know, whether people forgot their rights, whether people abandoned their rights, whether the agreement lapsed, is all uncertain. We don't know because we haven't had sight of this, right? We don't even know if the agreement was actually cancelled, because just bear in mind that this is more practical advice. You get a phone call from an attorney going, there's an agreement, how dare you? Like half the time, this attorney is trying his luck because he knows that if he can push you into a corner and you get scared and you want to back away, that you're going to suddenly freak out and want to move away from this, giving his client the opportunity to swoop in and grab the property again. But we don't know. I mean, when I used to do my sell and execution evictions, like this was the daily struggle. You go in, there's a property, like client buys it on auction, pitch up there, knock on the door. There's some tenant there, he's been there for 20 years, and apparently he signed a contract 20 years ago that he bought the property, he paid his deposit, and he hasn't paid anything since, but no one ever sent any letters of cancellation or anything like that. And he's he's hell-bent that this is his property and no one's going to take it away from him, right? Now, obviously, sales and execution are different, so we had a way of dealing with that. But in private deals, you're going to get situations where there's a level of uncertainty. But if the contract's valid, it's enforceable. The parties intended to be bound by it, and the seller effectively went off and sold to somebody else without having the right to. That is an act of repudiation. He is acting in bad faith for the most part. And if he hasn't properly terminated the previous contract, there's a very, very good chance, more often than not, that the previous contract that both parties found binding would actually be enforceable. But that's kind of the rule on the face of it. Then you have all these little exceptions. You have to look at the party's intentions. You have to look at whether there was a cancellation or an acceptance of a repudiation. So practical advice to the viewer: they've spent a lot of money on this property. So, and we had the very similar case now that we did recently in the High Court, where we bought the property. We were first, we bought it. And then the seller got very confused at a stage, and he had hired an estate agent. And this estate agent then came to him with a higher offer after he had accepted ours and accepted that higher offer. So now we had two competing offers, the second one being higher and ours being first. But what put a lot of pressure on this deal was the fact that the estate agent was pushing for the agent's comp. So now the estate agent's purchasers didn't want to walk away. My client didn't want to walk away. So we had this little dispute happening as to who was actually entitled, whether there was a lapse of the agreement. And the reality is we won that. We were there first. They weren't entitled to sell the property. And we went to court, and it was very easy and very quick for us to enforce this deal. But the one thing that we knew put a lot of pressure on the seller was the estate agent's commission that was due. And in your case, this viewer, is the amount that you spent on this property, because push comes to shove, right? If you spent money here, you can claim this back as damages. If there's an estate agent involved, there's going to be agents. Oh, apologies.
Estate agents' apologies. They will be.
I don't know. My phone just went off. So there's going to be estate agent's commission. Sorry, I missed that, Cilna. My internet connection just went off.
I'm sorry. I'm saying at least you can see I'm actually concentrating when you're talking.
Oh, nice. Thank you. So what put a lot of pressure on the seller was the fact that they were going to be liable for a lot of things. And that almost turned him to want to fight us. And even though we were right, he kept trying to push for that second sale because he had more to lose. So in your instance, because you've spent money, this is a good conversation to have with the seller going, either way, you're going to mess up. Because if you get this purchase price and you sell this property to the first guy and he performs, guess where I'm going to get my money back from? You're not going to see a cent of that purchase price. So I'm going to court right now, cancel, repudiate. I'm happy to repudiate the sale, but I'm going to go to court and I'm going to make sure I'm going to block those funds from reaching you. I'm going to claim every cent of legal costs. And because you acted in bad faith, I'm going to claim it on the highest scale possible. You could probably, maybe you can even get an attorney to kind of work with you on that. So highest scale possible. You're going to get the money that you spent. You're going to get all your transfer costs. You're going to get everything back. Hell, you could even try claim for loss of profit if you're going to flip this property, and just see how quickly that seller is going to run. So there's just a little bit of practical advice for you as the second one in line.
Yes. You got so excited about that evil genius plan. I love it.
Everything and the kitchen sink, Bruno. And I was just like, and you can. I was like,
and
wow.
Bruno is like, punitive cost order. I love it.
Oh gosh. No, but thank you so much, Cilna and Bruno. We've reached the end of tonight's webinar. It's, as always, such a pleasure to have both of you with us and to have our viewers with us as well. As we mentioned in the beginning of the show, we just urge all of you to take the necessary precautions to keep yourselves safe and to keep your family safe. And these are uncertain times, but in these uncertain times, at least, you know, you know that you have the Property Law Alliance, who will always have your back, and we really will. So please stay in touch, post your questions to the group. Please like and share the videos that you see. We've got a host of topics stemming back, I think going back good few episodes, 50 or 60 now, Cilna, and a wealth of information.
56 today.
56.
Wow.
Congrats, guys. So please, we urge you to
That's
go
a
back.
lot of time together, guys.
And have a look at the videos. There is something for everybody. And yeah, we look forward to seeing you all next week at 6 o'clock. Thank you so much, Cilna. Thank you, Bruno. Stay warm and stay safe. Cheers, everyone.
Stay
Cheers,
safe.
everyone.
Bye.
Thanks.